Can you hear me without a mic? Okay, good. I was hoping that was the case. I had one thing in mind, but actually this is actually small and intimate enough that I actually may deviate a little bit from what I have planned. So I have a script, and we will go through the contents of that script in a different kind of way. Instead of me actually, since I wasn't sure if I was going to stand before 25 or 50, let me modify what I was going to say and what I was going to do a little bit so as to get into a Q&A piece. As Dr. Clayton noted, I'm a historian, and I was a historian, as Bob Pratt knows, long before I became a university senior administrator. But I have been running universities in one way or another, being part of a leadership group at universities in one way or another since 1997. And so I was at the University of Michigan, as noted, as Dean of the Graduate School and Vice Provost for Academic Affairs. I was there when Michigan went before the U.S. Supreme Court in the Gruder and Grotz cases. Those cases would frame our contemporary understanding of the use of race, among other factors, in admissions at selective public and private universities in the United States. During that time, my time at Michigan from 89 until 2004, not only then did I play a role in graduate education, I had been, as noted, I was director of the Center for African American and African Studies. I would also run a program on the Michigan campus during the height of the Gruder and Grotz cases that dealt with diversity on campus. And so Lee Bollinger, who was then president, and Nancy Cantor, who was then provost, turned to me and asked, how do we make sure that the community itself doesn't fall apart in light of the contentious nature of what we need to understand about diversity in American higher education? Now, I was going to start this talk with a little piece from Lucille Clifton. Some of you may know Lucille as one of the more incisive poets of the 20th century. Lucille was born in DePauw, New York, in 1936. She grew up mostly in a Polish neighborhood. In fact, she told me at one point in 2006 that she learned to speak Polish so well that she was referred to as a little colored Polish girl. And this is this way in which her own sense of self was defined in relational terms. But Lucille was born in 1936, Depression-era America, in a place where when she decided to go to college, she had only one major option. She was 16 years old, and she would leave upstate New York and go to Washington, D.C., where she would enter Howard University. And she would say years later, Howard was not only the pinnacle of educational attainment for African Americans in the 1930s and 40s and 50s. It was the place she wanted to go. But it was also the fact that there were only so many options available to her in that era, in that period. And so to think about then what it means for a whole generation and prior generations of Lucille Cliftons and the range of options that were available to them. To really help put this in place, it probably makes some sense for you to actually hear Lucille speak. Or at least I think. It's mounted here. So does the Apple have the same effect as the PC when I click on the screen and the little button, it should go forward? There we go. Perfect. Thank you.
I'd like to read two poems. They're both fairly new. The first is called Aunt Jemima. It's in the voice of Aunt Jemima. What folks say I remind them of home. I who have been homeless all my life, except for their kitchen cabinets. I who have
that, we can actually close it down.
On a bed of
Partly, I wanted to give you a little sense of Lucille, first, not only as a historical figure and character, but in her own voice. Lucille would die in 2010. And so, in fact, it was almost 4 years to the date of the death of my own mother, and she and I had talked about that death in 2006. But I also use it as a way to remind us all that there was genius to be found in all forms and in all ways. And in the America that Lucille was born into in the 1930s was a place that prescribed and circumscribed the nature of how you identify and found that genius. By 1954, the U.S. Supreme Court would then tackle some pieces of this in its historic decision in Brown. Now, you've heard from Preston King and Lonnie King about the one part of social change in American life, the degree to which people engaged in social movement building. And that social movement building led to then changes in the ways in which we all interact and came to know each other through laws and customs and practices. But there also had been a series of generational fights over changing access as prescribed and limited in law. And by 1954, then the Brown decision becomes a very, very important one. I dare say most people actually never go back to actually read the statements and the decision that was rendered and the words of Chief Justice Earl Warren in what was a unanimous decision. So to start today's conversation, let me just read from you what the court wrote in 1954 in the Brown decision, because those words are important, because they say something about the change that occurred between 1896 and was separate but equal was understood to be the law of the land in 1954, when a new framing of possibility was put into place. Chief Justice Warren, who many of you know as the former governor of California and who was famous for, among other things, for interning Japanese during World War II, would then be the symbol of a liberal court. And there's a sort of interesting irony in that period between 1945 and 1954. He would write, "These cases came to us from the states of Kansas, South Carolina, Virginia, and Delaware. They are premised on different facts and different local conditions, but a common legal question justifies their consideration today in this consolidated opinion. In each of the cases, minors of the Negro race, through their legal representatives, seek the aid of the courts in obtaining admission to the public schools in their community on a non-segregated basis. In each instance, they have been denied admission to schools attended by white children under laws requiring or permitting segregation according to race. This segregation was alleged to deprive the plaintiffs of the equal protection of the laws under the 14th Amendment." Warren would go on, "The plaintiffs contend that segregated public schools are not equal and cannot be made equal, and that hence they are deprived of the equal protection of the laws. Because of the obvious importance of the questions presented, the court took jurisdiction. Today, education is perhaps the most important function of state and local governments. Compulsory school attendance laws and the great expenditures for education both demonstrate our recognition of the importance of education to our democratic society." Now, pause here. I mean, this is one of these pieces where even in 1954, education was not just presented as an opportunity for access to the material goods of life. But the court of stand in 54, education is key to a democratic society. And broad access to education is important to the maintenance of that democratic society. And the court will go on, "It is required in the performance of our most basic public responsibilities, even service in the armed forces. It is the very foundation of good citizenship. Today, it is a principal instrument in awakening the child to the cultural values, in preparing him for later professional training, and in helping him to adjust normally to his environment. In these days, it is doubtful that any child may reasonably be expected to succeed in life if he is denied the opportunity of an education. Such an opportunity, where the state has undertaken to provide it, is a right which must be available to all on equal terms. And the court will go on to say that, in effect, that what they are considering is the separate but equal interpretation coming out of Plessy, and they believe that to be null and void. And they will go on, as many of you know, then to remand these cases back to the lower level, say, come back within a year and tell us how you're going to begin to redress what had been done. Brown 2, as many of us know, the scholarship then follows in 1955. And for people my age, I was born in Virginia in 1955. The most classic of all phrases, all deliberate speed, came to mean something particular. I was born in 1955, and in the state of Virginia, all deliberate speed would take another 15 years. And so the schools, the public schools in Richmond, in Norfolk, and across the state would not effectively desegregate until 1970-71. And you think of that. So from 1954 to 1955, and I'm leaving out chapters where they closed schools and interposition and a whole range of other tactics were utilized, but it was 15 years. Because between 1971 and 1972, then, across the South, you see for a very brief period an attempt to begin to desegregate schools. What's fascinating is then to observe the implications of that particular framing, right? Because between 71 and 78, you see that for the first time then populations and proportions changing. To be autobiographical. And so in my high school in Chesapeake, Virginia, what became Indian River High School, Chesapeake, Virginia, when I entered in my sophomore year for the first time, I was in a school that was mixed. It was 55% white, 45% African American. Going back to that Brown decision about what it meant then to build a democratic society, I went to school with the kids whose uncles were the grand wizards of the local Ku Klux Klan. I know that because they told us. I had a geometry teacher who used to regale us with stories about the good old days on the plantation, notwithstanding the fact that at least half of the students in her class had a different narrative of those good old days. And we would challenge her, trying to still figure out to this day what that had to do with geometry. But nonetheless, Mrs. Overby made sure that she was teaching had two lesson plans she wanted to convey in that geometry class. One about geometry, the other one about social change. And we, that first generation, or what I call the transitional generation in the South, we were the ones who actually were part of then understanding both of those lesson plans. And then you fast forward. Because most people sort of think about social change in America as this long period and this long history. So what happens in 1978? Anyone? What happens in 1978? Since I don't know anyone's name, I can't call on you by name, but but I used to do that. And so I'm in a classroom. So what happens in 1978? You know the answer. Yeah, I saw, it's almost like conferring in one of those high school academic competition. You sort of lean over and whisper, and you sort of try to confer.
That's when my classmate teacher was the new busing laws. We haven't gotten to that point in our class.
Okay. Not quite. Well, busing is part of the background. So, yeah. And so, both in the South and particularly in the North, busing will become a big issue, certainly by 78. But what's happening in the courts? What court decision comes in? It's the Bakke case. Yep. It's the Bakke case, 1978. So think of it. Schools begin to desegregate in the South by 70, 71. And that's when we sort of think of then the ways in which the broader notion of affirmative action, as people have come to understand it, had a fairly short life. Because by 1978, the Supreme Court in the Bakke decision begins to redefine the use of race among other variables in admissions into, in this case, a graduate and professional school. It was a medical school. The University of California. It was deemed had no history of discriminating on the basis of race in the past. Yet it decided in this medical school, nor did the University of California at Davis specifically. For those of you who don't know, there are multiple campuses in the University of California system, and then there's the University of California at Davis. Davis then decided nonetheless that they believed that it had a larger mission to assist in the creation of this democratic society, decided to set aside 10 of the 100 seats in this medical school for African Americans. Alan Bakke, who was a trained engineer and who had been trying to get into medical school for several years, would apply to the University of California at Davis. Bakke would not gain admission, and he would allege it's because of these seats that had been reserved. Those 10 seats became part of a new sort of language about quotas in American sort of life in a really broad way. I bring us back to Bakke in part to go with the timeline. 1954-55, 1970-71, 1978. And if you go from 1978 to 2004 in Gruder and Gratz, and if you did a timeline across the board, you ask what period, during that whole period from 54 to 2004, 50 years, how many years were devoted to what you think of as sort of unadulterated affirmative action? And you realize that even if we sort of get to that period, it's the shortest period in that 50-year history. It's important to sort of outline this because sometimes we lose perspective of time when we start telling the stories about the past. And a decade takes on a multi-decade perspective. A few years becomes the experience of a generation or two. And I sort of draw you back then to the Bakke decision. Bakke did several things. One is, for those of you, again, who read, spend any time reading American constitutional history and just legal opinions. It was perhaps one of the most tortuously written cases in recent American history. When you go through, there were all kind of concurring and dissenting opinions. And there was a number. You have Thurgood Marshall at one end, who has spent his life working for the NAACP Legal Defense Fund, arguing for access to graduate and professional schools and public schools, who believed that then race should be a factor. In fact, Thurgood Marshall would go on to say that he actually believed in that you could not undo 200 plus years of history in 5 or 6 years. And that race should continue to be a factor as we actually look at who gains admission to schools. Other members of the court were less convinced. And so they would conclude on a compromise and say that race should be among one of several factors. And so you end up looking at and sort of telling this story of Bakke, because Bakke would then introduce new language of strict scrutiny and a range of other things that had to be applied. The elimination of quotas and a whole range of other tests that would emerge over the next few years. Fast forward between Bakke in 1978 and Gruder and Gratz in 2004. Or 2003, technically. What emerges as then the new argument? The new argument then turns on one about diversity. And so we go away from a 1950s framing talking about the importance of remediating racial discrimination in American life and culture, to a new argument arguing that diversity is key to the making of a democratic society. It was a little embedded and implicit in some parts of the Brown decision, but it had to be pulled out. And so most universities, I dare say my universities in the past and current, but most universities have embraced the diversity argument. And in fact, one of the great strengths of the University of Michigan case, in my view, in Gruder and Gratz, is not that the courts concluded in the Gruder case that Michigan had narrowly tailored a set of principles to allow for creating of a diverse class. It was actually the social science research that went in to supporting all of it. Twice in the 20th century, or once in the 20th century and once in the 21st century, twice in the last 50 plus years, social scientists have played a major role in influencing judicial decisions on questions of race. First was the Brown decision. So if you go back and read Brown, you realize some of the leading social psychologists of their generation would play a fundamental role in putting together a really cogent argument about what happens as a result of separation and segregation. But it also included historians like John Hope Franklin and others who also played a role in bringing together those cases. If you go to the Gruder and Gratz case, one of the things that Michigan did actually was to pull together another generation of social scientists who would go on to support in various briefs and other documents the importance of the diverse class. Pat Gurin, who was chair of psychology at Michigan, a social psychologist, and her colleagues would go on to demonstrate three things. One, students who participated in and learned in diverse educational settings tended, one, to be more engaged in their civic lives and civic communities. They were part of a broader democratic outreach. That was one. Two, individuals who learned in diverse educational settings also had a greater tolerance for hearing and accepting contrary opinions. They were able to actually wrestle with the fact that there were different views on the world. And third, such individuals also tended to have then a broader social network group, both in college and out of college. And Pat Gurin, Patricia Gurin, and her friends will go on, and her colleagues rather, will go on to argue that this is very, very important. But what if the diversity argument fails? And that's really one of the questions that I think that we need to wrestle with as a community. And I have text here, but let me just do it without reading from the text, where I sort of set up all of the arguments in a more sort of structured manner. Because the diversity argument assumes then that the court, the U.S. Supreme Court, will continue to agree, as Justice Sandra Day O'Connor did, that one, at the earliest, we have another 25 years before our society will begin to show the evidence of more inclusion. Okay, so Senator Day O'Connor talked about inclusion and projected, and in fact she would say before the Gruder and Gratz cases, in her inner ear, she could hear Thurgood Marshall talking to her. And that he reminded her that the decisions that the court made always had implications for everyday people all the time. So you go back to the Gruder and Gratz cases. One of the things that came out of it was that it not only had your admissions policies had to be narrowly tailored, and that is very strictly defined, but race had to be among one of many variables in the admissions process. So GPA from high school, SATs, whether you were in the band or the track team, whether you were president of your class and where you fit in the class. Were you number one or were you number 300 out of 300? All of these were sort of part of the constellation of factors. And as a university, if you use all of those factors, you have met, in effect, the Gruder test. So you would think then most universities would do exactly that. And they would make sure that the Gruder decision was the standard by which they would judge their admissions policies at the undergraduate level. So for those of us who are court watchers and trying to figure out what this current U.S. Supreme Court would take on, perhaps it's not surprising then that they've decided to take on a case, Fisher versus the University of Texas at Austin. And then on the docket for this session will come another affirmative action case in the use of race in college admissions. Now, many of us thought that actually we would not be back here in this decade. We had hoped that in 2003 that we would at least get 10 years. But here we are, not quite 10 years before the court is looking at the issue again. And there's a different court, right? So a number of the players folks have retired. And now, Elena Kagan, who was one of the last two justices appointed to the court, has had to recuse herself from participating in the decision because she was U.S. Solicitor, formerly U.S. Solicitor. And so it really will be 8 justices that will decide this particular case. Most folks are saying there are 4 who are going to probably turn it down, 3 who will continue, and there's 1 swing vote, Anthony Kennedy. Kennedy is in the middle. Now we could end up, best scenario, with a 4-4 split. Worst scenario, 5-3. And the diversity argument that has prevailed itself would be put on the side. So the case coming out of Texas. 2 young women, Texas natives, who were denied admissions to the University of Texas at Austin. The University of Texas, as some of you know, had been sued earlier under the Hopwood framework. There was referred to as the Hopwood cases. And as part of the solution there, the University of Texas system said they would come up with what's called the 10% plan. And so if you graduate in the top 10% of your high school, you're admitted to and you're a Texas native resident, you're admitted to the University of Texas at Austin. When UT officials went back to actually look at all of this, they also realized that they were missing still some talented young people, 1, and 2, the number of African Americans and Latinos and Latinas at UT Austin had dropped. And so after the Gruder case, Texas said, we will have the 10% plan. So 80% of all freshmen admitted to the University of Texas at Austin are admitted through the 10% plan. 80%. The other 20% are admitted through practices that all universities in the United States now follow, all selective universities in the United States follow. And I want to come back to the point about selective, because this is not a debate about access to higher education in the United States. It's really a debate about access to the most selective colleges and universities in the United States. But on the Texas case. So then that last 20%, there are 2 factors, 2 measures they use. One is an academic index, essentially a college academic index. They go through, like all other schools, and they decide and they look at the student's profile. So you may not have ended up in the top 10% of your class, but you still may have a 3.5 or 3.6 coming out of high school, and you have an SAT score that puts you in the 90th percentile. That kid gets in to the University of Texas at Austin. If they have an academic profile that suggests they should be admitted based on this index, they're automatically admitted. Okay. And so that's the first sort of part of that 20%. Then they start looking for those high achievers who were missed by the 10% plan. Then the next one, then they start looking at a range of other factors. Because you still need a flute player to be in the band. You still may need someone who is a highly qualified cheerleader who's going to do that in college. You may need someone from a particular rural area because you want to make sure you're covering the entire state. And so a whole range of other factors. Did you work after school? Did you have to support your family? So they have something called there's a personal index. So there's an academic index and a personal index. Race is one of the variables in the personal index. It's not the only one, but it's one of the ones. So this is why I come back that the Supreme Court would decide to use this particular case as a test. The primacy of the Gruder decision is an interesting one. It's interesting on two levels. One, because they can say we can point to an alternative, the 10% plan. But they also know embedded in all of the evidence, the 10% plan did not yield all of the results that were important, particularly if you harken back to Brown and argue that part of this is about democracy and how do you make sure you build an inclusive democracy. It will be interesting to see as we all watch the courts, because if you go, I encourage you to go read the decision at the appellate level, written by Justice Higginbotham at the appellate level. They go through in the clearest of language about why the appellate level decided not to overturn Gruder. And in fact, they go so far as to say that the University of Texas at Austin has done everything legally correct as prescribed by today's understanding. It makes you wonder, in some ways, then, is the court about to even question the fundamental notion of the diversity argument? That we have reached a level of maturity in the American society where diversity, as we've come to talk about it, is no longer important. An open question. It's a question, and I hope in this class that as you think about the decisions that and the actions of individuals in the 1940s and 50s, that we actually think about then the role that we all will play in the teens going into, to the 2000 teens and into the 20s, in terms of asking what questions we should be putting to public officials and all about what kind of America we imagine. Three points that I want to make now as we move into the diversity piece. One is that when we talk about higher education in the United States, this really has been a debate about the most selective institutions. There are and remain more seats. If you look at the entire complex, there are over 7,000 institutions, post-secondary institutions in the United States. And we fill a lot of the seats of those institutions with young men and women from around the world. We're at an all-time high with about 30% of Americans who now have some post-high school education. But as we look into the future, then you have to ask the question, what will it mean if we limit access? What will it mean if we assume that the questions that were so germane over the last 50 to 60 years have themselves been, in one way or another, reconciled? And I have data that I'm happy in the Q&A to talk about here, but I won't recite it for these purposes. So that's one question. Second question, if we eliminate the diversity argument, does it bring us back to a conversation about race? One could argue that in some ways, by having the Bakke decision come so early as it did in 1978, we really never finished a conversation about race in American life, and particularly in social policy. So what will it mean if the courts decide that race can no longer be a variable? Now, many of you would think, well, this is perhaps impossible. But let me go to the University of Michigan. So Michigan wins and prevails in the Supreme Court. And as a result, we have the Gruder Standard that's applied across the entire nation, except for in Michigan. Because after the Supreme Court, citizens of the state of Michigan tried twice to have a referendum placed on the ballot. First time, they did not succeed. The second time, they prevailed. It was called Prop 2, referred to as the new Civil Rights Initiative. The appropriation of the language of the civil rights movement was used by those foes of affirmative action in Michigan. And in an interesting, and I thought at one time a political blunder, but it turned out to be smarter than I had realized. They decided it's not just about race. It's about race and gender. And I kept thinking, I know the good folks of the UP will not vote in a way that will undermine opportunities for their daughters. But they did. 58% of the residents of Michigan who voted to overturn the use of race and gender in admissions in all state institutions as a result of Prop 2, the new Civil Rights Initiative. So when we start talking about the relationship between history and policy and change, how could this happen? How could this happen? How could a university in the state that prevails in one domain lose so badly in the other? And there are reasons, actually. I mean, I think the supporters of the affirmative action in higher education in the state of Michigan were not direct in their attacks and counterattacks. And so I can still remember sitting in a movie theater in Ann Arbor after I had moved to Georgia. I was visiting my son who remained there. And we went in, and there was an ad in between the movies of two girls at that point, 14 years old, no more, one black, one white, talking about the importance of education and et cetera, et cetera. But it was one of those ads when you realize in the end, you look at it and go, what was that about? It never said Prop 2. It never said that you should continue to make sure we have access. It was so amorphous as not to be direct. And as a result, it contributed to the backlash because even those who were trying to support it could not come out and name what they needed to name. So that's just one example. And where public policy then at the local or state level begins to undo what the courts. And so you lose in the court of public opinion even if you prevail in the judiciary. Last point. The demographic change that we're going to see in America by 2013, this country will be majority, quote-unquote minority. The anxiety over the change in demographics can be found and realized in all kinds of places. The questions about how we think about public policy and the relationship between policy and history, between history and social change, between social change and policy, can be found in some ways in that space in between the world that we know is shifting. And so we find ourselves coming back then again to the question of how do we build an inclusive democracy if we ignore some of the things that we think we know. So let me ask you a question. How many of you have ever played what I refer to as a racial guessing game? You ever walk down the street and you see someone and you're trying to figure out, okay, I don't know who they are or what they are. You're trying to place them in a box. Be honest, how many of you played it? Yeah. Why do you do it? Let's think about it. So if we end up saying there's something that is never important, yet we all find ourselves at various times ascribing importance to it, that we need to order our world in a particular way, framed by the sociology and the psychology and the history that we all know as part of this great land of ours. What does it mean that race is no longer important? That even the most educated find themselves playing a racial guessing game. And the questions that follow that moment where sometimes you slap yourself, I shouldn't be doing this. But you do it again anyway, and the next time, because you're trying to order. That sense of ordering the world plays out in many different domains. So I ask, if we eliminate the diversity element If diversity fails as a compelling state interest, will we find ourselves coming back to a much harder conversation about race? You could even, so the stem argument, has diversity been a way for us to avoid that much tougher conversation? Is that part of what's left to be done as we move into the end of the first quarter of the 21st century? It's complicated, right? Any biology majors here? I mean, because you live in the age of the human genome. That 1/10 of 1% of human variation that makes each of you different, and also embeds then those factors that we think of as race. That 1/10 of 1%. And so trying to talk about race in the age of the human genome comes freighted with all new kinds of questions and possibilities. And so as we look ahead and we look back, I come back to Lucille Clifton, in a way, to that young woman who grew up in DePauw, New York, who in the 1950s had only one option, because she knew that she had an opportunity to live a life beyond that of her parents and many of her relatives, of a life as a laborer or domestic. That world that has changed in so many ways since 1936 or 1952 or 1955 or 1978 or 2003 also has elements of the same, of the old. And so as we think about the diversity argument and where it fits in the history of American law and American social policy, I remind you that these are not just historical questions, they're contemporary questions, and that all of us get to play a role in deciding the final outcome. Thank you.
Okay, we have time for some questions.
Yeah. And I ask questions too, so as you can tell. So if you don't have questions for me, I'll have questions for you. And so I figure it's fair game. So questions, anyone? Thoughts? Yes. Would you tell me your name?
My name is Judy Smith.
Jim, okay.
Actually, I was at Michigan when the state information was going on, so I think that talking about it, I was living my life there
Yeah.
as a student in Michigan and really being involved in the whole affirmative action case. And I just moved here to Georgia last year, and so,
Welcome.
like you came from Michigan to Georgia. I basically felt it was there, I guess. But my question is that, when you talk about Brown versus Board of Education, you talk about the access to education issue, and there was really about that. And I'm seeing some parallel examples here in Georgia right now with adoption of students being, preventing from attending private institution. Now basically they're trying to fly the entire public institution in Georgia. And my question is that, I expected when I first came here, when I heard about the case, being going forward in Georgia, I was thinking that there would be more outcry from higher institutions than educators, and which I really don't find that's the case here in Georgia. And so I'm just curious that, I'm an educator myself too now, and for you,
Yeah.
that, you're an administrator at university,
Sure.
and what educators should do and should be doing about this case, because I consider that this is, they talk about this as a illegal immigration issue, but at the same time, when we talk to
Yeah.
people, this is really about certain ethnic groups. They
Yeah.
really, I think that these are all Latino issues and a lot of minorities basically, and I really think that this is also a racial issue too. And regarding those to access to education issue, basically that's what we're doing here, basically denying access to higher education to the entire generation of children. So my question is that, what should we do as educators about this kind of issue?
Thank you for your question. It's a very complicated one. Let me see if I can unravel it in a couple of different ways. Clearly, on the individual level, your ability to speak and have your voice heard is always a right and is a right any faculty member should exercise when he or she feels moved to do so. At the institutional level, I mean, it's a complicated piece, and there'll be some in this room who can correct me. But as I recall, at least a year ago, there was a distinction that was created between UGA, Georgia State, and Georgia Tech had one set of sort of guidelines, and then all the other state institutions were slightly different. And so there was a separation. Major research universities got a little more of a pass in a certain way than some of the others. And this is this interesting part of it to understand. And from where I had a trustee come to me asking what we were going to do to, as a private institution to reflect the state mandate, and I said at this point, my hope to do nothing. I didn't see why this was an issue. And there was an article in the New York Times Sunday magazine about a little more of a year ago of a young woman, because in California, for instance, which is an alternative, California has different provisions that while you may be undocumented, but if you have the wherewithal to actually gain admission to one of the University of California institutions, you can attend. And so, and as I was saying to my trustee, and here was the analogy, I said, look, if you can imagine that you're first generation, that your parents are coming here and knowing there's a specter that someone will be looking for them because they do not have the documentation to say they're in the country legally, that you have been able to achieve sufficiently enough through elementary school, middle school, and high school, overcome all of those obstacles and be admitted to one of the most selective institutions in the United States. I want you. Because you tell me something about yourself that's different than a whole lot of other people. Now, if you were outside the United States, I could bring you in as an international student. You just think of that. I mean, so there's a public policy solution. They're an international student. And we have no prohibitions on international students if they gain admission and get a visa from coming and attending. It's only because of this sort of status. And so I think part of the question, and it goes back to the heart of your question, is why do we do this? I mean, who is being aided by having that kind of high wall? Would we not be better off educating those who have excelled? Are we not better off rather than putting up new barriers? That's the public debate that needs to be had. And I think one way to deal with it are then to use the public forum inside of our institutions to debate those most critical issues of public policy. It's a complicated answer to a very, very complex question. And I'm sure that there are members of this administration who spend a lot of time going back and forth to Atlanta and the Capitol, trying to figure out how to negotiate the gray spaces that exist in all of the laws that we put into place. But no, it's a huge issue. And there are models out there. There are alternative models. Other kinds of questions. Thank you for the question. Other kinds of questions. Yes?
Well, this is sort of, I don't want to maybe spend too much time in this area, but I was thinking about the Bakke decision, because a lot of the sort of language around that Board of Regents decision with those 5 schools is that those are the 5 most competitive schools, and that those are the schools that have been shown to, and I think this is almost the exact word, like deny qualified applicants when undocumented folks have access. So there's, to me, it sounds very much like what Bakke was arguing, that he was qualified, that people that weren't qualified were getting access when he shouldn't have had access. And so I guess I sort of wonder.
Yeah, in this case, what's evolved over the years, let me draw a distinction between Bakke and Gruder, and even Gratz. Gruder was the law school case, Gratz is the undergraduate case. By 2003, by the time the Michigan cases were fought before the Supreme Court, no one debated that the students who were admitted were qualified. In fact, if you go back and read the district level decisions, the plaintiffs concede that the students of color who were admitted were qualified. Bakke, they were raising questions about whether they were qualified. So in 78, those are questions of were the students qualified, those 10 students who had the seats. But by 2003, there's no question. They concede. It's actually in the court record. They were qualified. So it's not about losing out to someone who is not qualified. And in fact, on the Michigan case, things I left out, but we'll add, in the Michigan case, the most fascinating piece, you know how we ended up with the Gruder and Gratz case to begin with? There was a former state legislator who put an ad in newspapers in the state of Michigan that said, if you're white and you believe you've been denied admission to the University of Michigan because of your race, send us your name. 500 individuals did. And from that 500, they called and came up with the individuals whose names are now written into the Supreme Court history. So, and in the case of the undergraduate student, it's even more complicated. I mean, it's part of knowing all the inside details. She was not denied; she was waitlisted the first time, and there's high probability she would have been admitted. She actually enrolled in the University of Michigan Dearborn, so she actually enrolled in the University of Michigan. She just did not enroll in the University of Michigan at Ann Arbor. And so I remember asking the lawyers, does she even have legal standing to sue the University of Michigan if she's actually a student in the University of Michigan? And they went back as a fine point that she wanted Ann Arbor and not Dearborn. And so it's a complicated history when you start pulling apart all of the bits and pieces. But there's very little question anymore that we're talking about individuals who are qualified. Now, coming back to the analogy with students who are residents but not documented. I have not heard anyone say that anyone who's being admitted who's not qualified. In almost all of the rhetoric, both in this state, in Alabama, in Arizona, the students themselves are, generally speaking, not only qualified, they, by the ways we look, taking a holistic review of all students who have been admitted, they have excelled in some way in particular because they've overcome a whole range of hurdles to get to this point. And so in some ways they may be overqualified, depending upon how you look at both the personal inventory and the academic inventories that are indexes that are used. But it comes really back to then, are these seats so precious that unless we can prove that you're a taxpayer in X state, then there shouldn't be a place for you. Now, the challenge is, and here's another part, the challenge is that most state universities, outside of North Dakota right now, North Dakota is the only state that's had a surplus in the last 3 years. Every other state, for the most part, has been dealing with deficits. So you know how most universities make up their deficits? They have a certain percent of students they bring in from out of state. And they tend to charge those students a higher tuition. You know, yeah, I was going to say you're probably familiar with that. You're not from Georgia, so yeah. And so if you think about it, I mean, play this out. So we've already said that we're going to set aside some seats for students who are not residents because we're going to charge them a higher tuition. And then we're going to say, but you over here are not qualified because we can't put you in this category because we don't have the right documentation. We don't want to put you in the other category, although you're a resident and you've overcome things. And so it's a fascinating public policy question. But it's more than that. There's a moral question here. There's an ethical question here. There are a range of questions that are part of the overall framing. There are invariably political questions here. I mean, the questions, why would a politician believe that this is the thing to campaign on? Unless they believe there's somebody actually going to vote for them for campaigning. And so what are they then, what's the general populace saying about this set of issues? If they have politicians who are actually saying, I will do what you're directing me to do. And so there are the political questions there too, but it's palpable set of questions. Others? Anyone else with a thought, a follow-up, a question? Yes?
Oh, could you talk a little bit about like schools that are not like accredited? Like if you went to high school, say, in a territory
Yes.
that's not accredited, what would be your or why are those schools unaccredited? What does that mean for higher education?
Yeah, let's see if I can. Let me start at the higher ed side and then work my way back to secondary and elementary levels. Clearly, you want to go to a college or university that's accredited. I say this as a former graduate dean who was going to be sued one day by a person we would not admit to the University of Michigan because he had opted to go to a non-accredited college. And I actually was trying to be nice, but I said, look, this is not my problem. We have a pretty clear line there that to enter into one of our graduate professional programs, you have to have graduated from an accredited institution. The fact that you spent 4 years knowing that you were going to a non-accredited institution is something you need to talk to with your institution. That lawsuit went nowhere, but it was one of these cases where I couldn't figure out. He signed and knowingly had signed 4 years worth of tuition to this place and was religiously affiliated and reflected his particular point of view at that point in time. I say that in part because accreditation then means that you are eligible for loans, federal loans, and other kinds of governmental support. Without that kind of accreditation, then the institution, UGA, Emory, or the others, could not take advantage of federal dollars. And so that's really why most of us look at accreditation and why it's important. It comes with access to certain resources. Now, if you look at look around the world, there are different ways in which we then affirm that a student entering an undergraduate program has, by and large, met the admissions standards. Okay, so one way that we do it, so there are kids coming in from international schools, and we're trying to determine whether or not they're accredited by somebody. Not all of them are. And so then the entrance exams themselves become another way of marking whether or not we think they have the wherewithal to succeed in our environment. And so one way is then you take in either the ACT, the SAT, or you take an IB sort of curriculum and test there that affirm that you have a certain background in preparation. In other cases, then, there are international bodies that will come in and serve in some ways to accredit an institution. So even if your home country doesn't provide it, there are other ways to do so. When we come into the United States, and this is sort of coming local, that's the more difficult one. So if you're homeschooled, so individuals who are homeschooled, there are agencies and bodies for homeschooling that will attest and affirm, but usually it requires you to take still one of the SATs and ACT scores, and somebody else is going to authenticate that you have done the work you supposedly you claim you've done. If no accrediting body is there to affirm, there's no national sanctions, then you're actually in trouble, and there's no way for us to independently verify that you have the record that you claim. It is very difficult. It's very, very difficult. In all my years, I started as a faculty member at UC Berkeley in 1984. I moved to Michigan in 89, moved to Emory in 2004. The Dean of Admissions reports up to me at Emory. I can't think of a case where we've had a student whose profile suggested they should be admitted, and we had some questions where we could not find sufficient answers to admit them if they seemed admissible on all other grounds. So I don't know how big a problem this is. It's noted, but I'm not sure how big a problem this is. At least at the secondary, going from secondary into the first years of college.
Well, I was just going to say, because I moved here from the Caribbean, from the U.S. Virgin Islands.
Yeah.
And I was working in the schools a little bit, well, middle school mostly, but the high schools were not, it was pretty much a dead end after high school. The territory,
Yes.
they don't really
But they could apply for admissions to universities throughout the United States in the Virgin Islands. I mean, this is whether they knew how to do so and if there was anyone there. I mean, this is a different question. There are people all over the world. I was in India last summer and talking to higher ed people, and there are Americans who live in India who prepare young people in India for college in the United States. They align them with admissions officers, and they make sure they get the right courses, et cetera, et cetera. And so, to be honest, there's a market. I mean, so if you know the Virgin Islands and there's no one there and you want to go back and position yourself as that person, there is a market there. But I know in other parts of the world, it's a pretty active industry. And the folks know each other. And more than that, the admissions counselors at major colleges and universities all over the United States want to know them. Because if there's a talented young person in the Virgin Islands who should be in one of our colleges, the last thing we want to, the first thing we want to know is the name and how we gain access to them. Were you? Okay, yes.
I like the question you posed earlier when you discussed eliminating the diversity question.
Yes.
And what does that do to the conversation on race?
Yeah.
Because we actually were sitting here prior discussing like the cultural diversity course here and discussing, well, what do we talk about in that course? Do we talk about race?